All right. Good afternoon, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for September 16th of 2024. Brad, go ahead. Take us
Well,
away.
our first one, which is really exciting, but people won't find it necessarily exciting unless they're in Jacksonville. But we have but as a legal matter, this is a
Yeah.
big deal. I don't know how big a deal yet, because I haven't. Well, I got to read the complaint. Of course, it's a settlement. In any event, here's what we have. There was an incident in
2020.
2020 where a shipping company puts 2,000 or so vehicles, 2,420 vehicles on a ship. They didn't follow their procedure to disconnect the batteries. They left without engaging an alarm system, the fire alarm system. So clearly negligence. But and there were severe catastrophic injuries to firefighters. So in Jacksonville, they've now settled this ship explosion for $16 million. And unfortunately, big money comes with big injuries, right? You never like seeing this because, it's as a result of people paying a severe price. But on the legal side, there's two major issues. This was what's called a maritime decision, meaning what happened out at sea and not as part of a state's law. So
Well, at sea is kind of because if you're in the water at dockside,
right.
okay, and I think that's really what was happening here, but that's considered to be part of under the jurisdiction of admiralty law. So
Yep.
I don't know. Did you study admiralty law in law school?
Tulane had the #1 admiralty program in the nation. I did not. That was never going to be
It
my
was an
thing.
elective. If I had one more elective,
You would
I
have
would
done
have
that.
taken admiralty law. And it's an area I took bankruptcy law, so I'm pretty good at bankruptcy, but I didn't study admiralty, and it's a real specialty.
It is.
I'm not, yeah. So
And here, the issue is, well, think of generally firefighters injured. So first, do you have the right to sue normally it's under your state's law, right? The firefighters rule. Now remember, the firefighters rule was created at what's called common law. It's created by judges. So it's not necessarily in any one given state a law that says firefighters can't sue, police can't sue. It's created by judges, but it's generally universal until a state like New York and several others have come out and gotten rid of in a law that's passed saying, no, firefighters have the right to sue for certain injuries. Here, however, and we don't have a court decision, this is a settlement. But obviously the shipping companies must have believed that they had liability.
there was, Brad, actually, and I'm not sure if we had started the roundups, but I had covered this case earlier, and there was a decision, a federal court, this U.S. District Court for the Middle District of Florida had ruled that the firefighters rule does not apply in this context. So again, there's a link in the case to the earlier coverage of that decision, but the court ruled, and I think that was their motion for summary judgment, and the firefighters were able to get by it.
And without having read it, my belief, I would agree, because since this is maritime law, if that's what applied, right? Forget Florida's law. It doesn't apply a state's law. And as I said, that the firefighters rule is created by a judge. So unless a maritime judge had created the prohibition, and I want to go read the summary judgment motion, see if I'm right, without a judge in the maritime world saying, look, on the sea, firefighters can't sue, then there would be no prohibition to them suing.
Yeah, I've actually got. Let me read to you.
Please.
From going back to my earlier coverage of it. And this, I'm quoting from my earlier blog. In wrestling with the firefighters rule, the court concluded the question then becomes whether Florida's policy. So they went back to state law. Interesting. The question then becomes whether Florida's policy of allowing firefighters to sue those who negligently start fires is consistent with the general maritime laws, principles, and policies. As noted above, general maritime law imposes a duty of reasonable care on anyone on board a vessel. This is consistent with Florida's policy of treating firefighters as invitees rather than licensees and establishing a more general duty of care compared to the heightened one that exists under the state's firefighter rule. In addition, the majority of courts applying maritime law's duty of reasonable care have allowed first responders to recover against individuals whose negligence caused the emergency, giving rise to their presence. And there's some more blah, 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 blah.
That's it. That's it. So maritime law doesn't prohibit it. State law is consistent. So it probably didn't matter choice of law, maritime or state law, that it's good for a court to be able to say, listen, we don't know which law applies, but it doesn't matter because same result in either case. And that's what happened. So it is a big deal because don't forget, now just a few years ago, we had the New Jersey, same issue, the New Jersey boat fire, also fatal. And you're going to have the same issue, or maybe not after that summary judgment decision. New York, of course, has come out. I don't know what New Jersey did. I think in that case, that was a New Jersey
was it Delaware? Was it Wilmington, or was it New Jersey?
I think it was New Jersey.
Let me see if I got it. Yeah, I think.
Either way, under maritime's, I think, universal, right, to anywhere around the U.S. would be the same maritime law. There's only a certain number of maritime courts, so that same reasoning should apply. But this is good for those of us who go on to boat fires, things like that. I don't know, because I don't know anything about maritime laws. What if you get injured on a lake?
Right. You're right. You're right. It was New Jersey. Was it Trenton? What port? It was a.
Or was it Jersey City? I don't remember. I'm thinking it's Jersey City, but I'm really pushing my limits.
Yeah.
But in any event, where it docks an ocean or the Gulf or anything like that, and not a surrounded body, this should apply. So, which is good for us. Okay, you want to keep going? We got another settlement.
Yeah.
This settlement, I don't think is shocking. You and I have covered this a number of times. We have a $7 million settlement. As opposed to the 16 million, we have $7.2 million settlement where the
this
family,
is one plaintiff.
What? Yeah, one, exactly. Where the family, this is where we had threats, and this individual, and get me if I'm right, because I'm doing by memory, where even the two firefighters in the same department, maybe same station, but in any event, one of them goes and kills the other one, but I think it was off property. And it wasn't at the firehouse.
No, I've actually had some communications with some of the folks involved here, so I'm not breaching any confidence or anything. I can't disclose where they came from, but you have two firefighters. I believe they were both engineers, and there was actually an issue. Only one of them was going to be able to get a certain position at that station, and the firefighter who did the killing, I think his name is Tatone, had a reputation for making threats. He really didn't like this guy, Carlone. And then when it came down to one of the two of them having to leave, whatever, it just escalated into this real bitter dispute between the two of them. But Tatone was off duty. He came back to the station. Now, they had a little dispute at shift change. Tatone went home, came back to the station with a gun, shot Carlone, and it happened just outside the station, but it was at the station. Then the captain, Captain Sandoval, came out to see what the commotion was, obviously heard the shots, and then he got shot as well, and he was critically injured. He ended up with a $2.6 million settlement. The firefighter Tatone then went back to his own house, set it on fire, and then committed suicide. So,
and and so you have the question here of workplace violence. Should the department, the municipality, should they have known? Clearly, they thought there was enough chance of losing where they settled.
Now you raise it. You just said it's workplace violence, and my mind immediately goes to mental illness. Okay, mental illness, which in turn is one step away, mental illness leading to the violence. And we're not very good at dealing with mental illness, and recognizing it. We don't have the in-house capability. Like most law enforcement organizations have psychologists, staff psychologists, or at least on call, because their folks are walking around with guns and they're walking around with the authority to really screw people's lives up. So you can't have people with that kind of authority. But here in the fire service, we tend not to. Some departments they're starting to. But in terms of, if you deal with this as a violence problem, there's a question. I think a better way to look at this is really a mental illness problem, recognizing and getting this guy the help that he needs.
Right, not from the liability perspective, right?
Right. No, no,
Liability,
no, I'm not, I'm talking
failure to
about from the leadership.
diagnose mental
Yeah.
illness, right? I mean,
Right. Yeah. No, but at the end of the day, the department has an obligation to intervene, based on reasonable facts. And we don't know all the
right.
facts, but apparently
There
this
was enough.
apparently there was a history with this particular person. And it's unfortunate. There's no, and I don't think we really talk about winners in any of these cases. It's just, how bad does it get? And
Right. Right.
yeah,
Agreed.
really
So,
unfortunate.
look, I think the take home lesson to everybody is if you suspect that one of your employees may become violent towards the public or another coworker, you
Yeah.
need to send them home, get an investigation, get a professional evaluation, and
Mhm.
then determine the threat level. If you did that and your determination was wrong, that'd be one thing. You probably
Right.
not a lot of liability for that. But if you did nothing and you
Mhm.
just ignore everything, your chance of liability is huge. So we have, look, in the volunteer fire service and the paid service, but we have meetings where people stand up and yell and they're mad and they're throwing things and they're aggressive. I've had pushing and shoving incidents from clients in parking lots. And it's a far step from pushing and shoving to going and getting a gun and killing someone.
Right.
Or is it? Right. And when you start hearing the recitation of, oh, he yells at every meeting and finger pointing and spitting in their face and threatens violence,
Mhm.
somebody would assault somebody is not a murderer necessarily, but did you take action? So where I'm telling our volunteer listeners is if you've got that person, and a lot of us do, who's that yelling, assaultive, whatever, you better get them to tone it down immediately, or you need to take action to get them out. Because that you can't tolerate
Well,
yelling, screaming, violence,
in my
threats.
experience, one of the problems that happens is when you have that sort of, dynamite person, he's just waiting to go off. They may be a high performer, and we tend to
Yes.
kind of look the other way at it, and
Yes.
that's just Joe. And then, somebody else who's maybe a low performer does the same thing, and now you're trying to deal with that, and the low performer is saying, "Well, why didn't you do it when so and so?" And so there's a consistency issue that we struggle with as well. But I think access to somebody who can do that threat assessment is
Yes.
really important.
Yeah, and
Okay.
use the key terms because
Right.
that's what federal law calls workplace violence. It's a threat assessment, and you
Right.
need a professional threat assessment.
And
To
you don't want to wait until it happens to go try to find somebody. You want to have like an on-call staff
yes,
person or a contract with someone who's got the credentials to do that threat assessment and evaluate whether or not the person was actually just joking and really isn't a threat, or whether there are some legitimate concerns.
right, and then you throw in mental illness or mental health to all of
That's
this, and
that's
now you're
that's at the bottom
taking.
of it. In my opinion, that's at the bottom of this.
Yeah,
So,
because it's not predictable, right? How you act in a bad mentally stressful or mental health condition is just not predictable. So I agree. Threat assessment. Okay. Let's go back to Florida, where this is interesting. We have two former fire officers are suing, alleging they're wrongfully terminated in violation of their First and 14th Amendment rights. They've sued the city manager, and they're alleging that the city opposed the IFF formation,
mhm.
that they created a hostile working environment, that they fabricated charges, all presumably in retaliation of trying to form a union. And so there was a video. I watched a video you posted. It's interesting, but basically it's saying that their rights to free speech or free association. That's the bigger one, right? Because they're not allowed to form the union, and because you're retaliating them against the union. I'm surprised in this day and age that we're having anti-union formation. Look, I tell people, you hire one firefighter, the IFF is coming in. And that's not necessarily a bad thing. There's some benefit to negotiating with a union versus a benefit to negotiating with 20 different employees or 2 employees. It's not the worst thing. So, and it's a given. Right? When they want to unionize, they sign the cards, they hold the vote. It's a given.
Mhm.
I don't know why people are retaliating. This, especially in Florida, where there's heavy IFF presence.
Well, Florida has some urban areas that are fairly pro-labor, and then you have some places, and I'm not familiar with Niceville. I think there's a little bit of irony there in the name.
Yeah.
It doesn't sound like they're being very nice to these guys. But again, you don't know. You don't know what, whether these were problem employees, but it's
Right.
certainly from the complaint, it doesn't sound it. It sounds
No,
like,
but of course not, right? That's
right. Yeah.
wordsmithing. I mean,
Right.
look, I can see this from the other side as well. We don't know, so we're not saying anyone's right or wrong, but I could see this as we are the problem employees, and now we start raising union issues, and we start trying to protect ourselves by screaming union. And I got to tell you something, because I have this lawsuit I'm dealing with now in front of the NLRB, or investigation at the moment. And obviously I can't say much on this, but I will say this. People aren't stupid. People, because of our show and others, learn their rights. And what I finding that people do is they mix their attempt with a little bit of their rights. I'll explain this. And they try to do what they want to do to cause disruption, but then they're like, oh, but I'm also talking about my terms and conditions of employment. And so the real reason when you come back at me is not because you said horrible things about us and you breached confidentiality and you did all these things you weren't allowed to do. It's really, I said terms and conditions of employment, so now you can't come after me. And that's not the law. But the problem is, right, if I'm your employer, to our listeners, and you say I'm incompetent, et cetera, and you badmouth me all over town, and you say, and that's why you're not paying me enough money, because you're incompetent, or your decisions are leading to me not getting enough money, but you're incompetent and you have no business being a director. Well, I can fire you, right? I believe I can fire you because you're insulting your employer in public.
Well,
The problem is,
they've teed up that claim there, and that's the challenge.
that's the problem.
Sort of disentangling the two issues is a problem.
And that's what happens here, right? We don't know what's happening here, but it could be okay, well, I know I'm getting fired. I'm complaining about things, but now I throw in the word, and I want to unionize. Mm-hmm. Why are you firing me? Was it because I'm a bad person and I'm just trying to protect myself with unionization, or are you really coming after me because I'm a union? And as you said, they've teed it up. It's very dangerous. But as an employer, you also don't want to kowtow to all of this either. And just because someone says, oh, you're a horrible whatever, or they do something wrong, but then throw in union or terms and conditions of employment, like salary, hours, whatever, it's nerve-wracking. It's a choice. It's a confidential communication I have with my clients all the time, that is it worth it? Mm-hmm. Right? And a lot of employers are like, screw them. Let's get rid of them. Because otherwise, if we don't get rid of them and fight this, everybody's going to do the same thing. They're going to, well, I was late 6 times in a row, but I want to unionize so I can have later hours. And we fire you because you're late, but you said the word union, so now I'm going to sue you over it. Mm-hmm. It's a tough position being an employer these days.
It is. And again, people who create problems in the workplace and get themselves into a situation where they know they're going to be shown the exit, it can find something to, I call it teeing it up. Whether they might, I know you used to, we will again do like the FMLA class, Yep. And so if the person's abusing their sick leave, and they know they're about to get terminated, they're going to throw up the FMLA flag, yep. Or maybe the ADA flag or whatever. So again, whether that's what's going on, who knows? But again, just another example of the types of lawsuits we're facing.
And if people would document everything, so there's a timeline, so problem employee, union accusation. Well, wait a minute. We're going back to the first 3 problem issues you're using, right? On this date, now you raise the union issue. You got to be able to paint the timeline, but without good documentation, for so many reasons, you're making it hard on yourself.
That's a great point. And in this complaint, he did allege good employee, union, and then the problem started. So yep. Again, documentation is important. And what happens, especially up here in the Northeast, okay, I don't know, I can't speak for the rest of the country, is where somebody gets themselves in trouble and something goes in their file, and then after 6 months it comes out. And they look like a good employee, and then they get themselves in trouble again. It goes in for 6 months and it's out. So now you have somebody who hasn't been a good employee. You go back to their file, there's nothing there.
Yeah.
And now they can say in a complaint, I'm a good employee. There's nothing in my file. So.
Right. And verbal counseling as well. It's supposed to be verbal. Is it written? If there's written recommendation, all right. I mean, we have all these problems. Okay. In any event, but document, right? And there's listen, writing things down as an incident list. So-and-so was late on this day. Okay. You still can have a record. You still have your records to show they're a bad employee, but you better have been looking at them before they raised the issue, the union card, the whatever card, right? So, okay, let's go to LA. Back to LA.
LA. Huh?
Yeah, so here we have an assistant chief is claiming reverse discrimination. We've seen this case before, certainly, in Connecticut. We've seen these cases go all the way to U.S. Supreme Court. But here, basically, we have an assistant chief who says he was the most qualified person for the job. But that's not the story here, because apparently the chief, and I could see this happening. I'm not saying it did happen, but I could see it. The chief gets some direction that they're going to hire a minority, and they've predetermined that the only ones who are going to get this job is a protected class, female, black, whatever. And they're announcing, listen, this position is only open to a certain race, gender, protected class. Now, by the way, that alone is problematic, but is not fatal, because you can, for example, if you said, listen, 100% of our officers are white males, we're going to correct that by specifically trying to increase the number of protected classes, minorities in these positions. I think you can do that.
Yeah, I think you can too, but I think you're better off, you're safer being a little more discreet about it.
Yeah.
Just like that's kind of behind the curtain, kind of whispering, you really don't want to be as overt about it. But
Right.
Can you? Yeah, you can. If you will want to have documentation that your organization historically has somehow put barriers in place to their advancement and say, this is our remedial plan.
Right. And look, I wouldn't do that. That's not how I'd advise a client. I think we should try to equalize and normalize races, genders, everything in the fire service as a percentage base, right? If the community is 30% African-American, then our officers should be 30% African-American. But I don't believe on exclusions. I believe on doing it, okay, if everybody's equal, if you've got 20 years, I've got 20 years, if everybody's equal and they're all good candidates, fine, let's not leave it to an interview. Then we can go on race, et cetera, and other characteristics to address the problem. But if you're not equal, that just has so many bad problems. And in the fire service, more so, because it's not like we're saying we're appointing a bad accountant. This is, okay, we're going to make somebody who's not qualified a lieutenant based on their gender, race, whatever. That has real ramifications, because now people feel unsafe. They get mad because they're fearing for their lives.
It sets them up for failure. It sets them up for failure. And then now you're just defeating the whole purpose of what you're trying to, you're trying to move things forward. So
and here's my suggestion to people. If I ever got this phone call that says, listen, we want to only promote minorities or whatever, that right off the bat, I'm going to either A, get somebody who does nothing but that work, right? Or B, I'm going to spend a significant amount of days researching the instances where courts have allowed and not allowed, and what the statute allows and not allows, right? It's one thing to say we want to equalize to our community's percentage. We've seen that in Syracuse and Boston, right, where they have these court ordered, you're going to hire in an equal percentage. So there is very strong court support for getting your community's population in line with your departments.
But you've got to do the research ahead of time. And you know what? LA County may very well have done that. They may have done that. They may have done their research, and now the chief is just saying, look, we've done the research. And some of you aren't going to like this, but this is going to be our remedial plan. I think that's the key. My reading of the cases is that it has to be some sort of conclusion. Now, there was a question at one point whether or not it had to be a judge that ordered it. And the Supreme Court has concluded no, but there still has to be that finding that we've had this disparate impact and that this is part of our remedial plan.
Yeah. Yeah,
So
agreed. So just, just to say, hey, we need more women, we're going to hire women in place of men. That's probably not the best idea. But there are ways to accomplish it. Just really, as you said, that may have already happened here in LA. You've got
right.
to imagine
I've got
that,
to imagine. Yeah.
yeah.
I mean, to become the chief of the LA County Fire Department, they don't just, that's not an election. That's not,
Right.
you're talking about somebody who's got should have enough political savvy to realize that. So I would imagine they did, but who knows? We'll see how it all plays out.
All right. Lastly, we're in North Carolina. We've got a volunteer fire company, though it's not really, right? I say not really from New York's perspective, because we
They're a
don't have paid
volunteer
on
fire
call.
company. They're a volunteer fire company with paid employees.
Paid employees, right.
There you go.
So they're sued because, and this is very interesting. I didn't know if they took their firefighters' number, they could have, but they're sued effectively for not paying overtime over 40 hours. I'm presuming initially they never elected to have a certain, the FLSA overtime. We're going to allow you to do 53 over.
They can't. That's all. You have to be a public entity to take advantage of the 7K exemption. You have to be a public entity.
But that's my question. So in many respects, harassment and different claims, we see volunteer fire companies treated as municipal entities or employers.
The FLSA has that down. They have it could not be clearer. Volunteer fire companies cannot. Now, there was one case that we're familiar with in Louisiana where there was a 50, well, not a 508, it was a private nonprofit fire department.
Okay.
But think about this. It was created by a municipality. So the municipality created it. The board of directors were elected officials. And so it wasn't truly a privately created organization.
Let's stay on this topic. Let's not get off this. So the rule you're saying, because this has a big impact. The rule you're saying is volunteer fire companies, if you're strictly volunteer, cannot use the in excess of 40-hour overtime rule.
Correct. 501c3, anything created other than by government has to be created by government.
Well, that's the thing. So in New York State, for example, a fire company cannot be created except with the consent after a public hearing by a municipality. Does that change the paradigm?
Well, who's on the board of directors?
Volunteers elected by volunteers.
It's not. It's a private entity. In this one, the mayor, the parish council basically ran the fire department. So it was like you could call it a quasi governmental entity, but that's the only case that we have seen where something that is created in the same mechanism that you or I could create a nonprofit. And here in Rhode Island, that would be distinguished from a fire district, which is created by the state legislature. And I know some states have mechanisms to create fire districts in other ways.
Right. Those are governmental entities without question.
Those are governmental entities. So,
but the fire company that's created by, and only exists so long as the municipality wants to contract with them, but that still doesn't give you.
Well, does it no longer exist, or it no longer exists as a fire department?
No longer exists as a fire department. It would be a not-for-profit corporation, but its firematic activities only exist and can be continued so long as you're contracting with the municipality.
And that is how it should be. Okay. But the existence of it as a private entity isn't affected by that governmental approval. They can't function as a fire department, but they can have a bar, they can have a restaurant, they can do fundraisers and all that. But they cannot operate as a fire department without the municipality's consent.
Okay.
Yeah.
Very, very interesting. I've always wondered, why aren't more paid on call departments, right, taking advantage of the, now I know.
Yeah. It's got to be a public entity. It has to be a public. The term that the FLSA uses is a public agency. And then they have a definition in section 203 on what a public agency is. So that's scary that I know that.
No, you should know that. That's well, you lecture on all the time.
In the memory banks here. So
anyway, so that's what we got out of North Carolina, but they just think, they should be paid overtime, and they may very well be right. that they've adopted an excess schedule, I think 117 hours or right over 117, and that they couldn't do it. So
all right. Well,
that's it for the
interesting
week.
Yeah, interesting week. Several good settlements. It does. One of the things I notice is the settlements seem to come out and then like all at once, because there was probably 10 different settlements I could have covered this week. You can only cover so many. And then it seems like the motion for summary judgments all come out all at the same time, and the employment discrimination cases come out all at the same time. So I don't know. There's got to be we'll figure it out. There's got to be some sort of a scheduling type of thing where all of the courts seem to come out with their decisions all about the same time. So at any rate, that'll do it for another edition of Fire Law Roundup. We'll see you all next week. Brad, thank you.